Good morning, everyone, and welcome to today's webinar, where we're going to be giving you an introduction to the Employment Tribunal process. My name is David Clay, and I'm going to be hosting this talk together with my colleague, Emma Ferdinando. Now, this should be, it's going to be a relatively high-level talk. So it's a good one if you've not had too much exposure to Employment Tribunal litigation in the past, or if you're just after a bit of a refresher. But that said, if you do have a bit more experience with tribunal claims, then there should still be some useful snippets for you to take away as well. Before we get going, I've just got a few housekeeping points to run through. So I'll go through those now. Obviously, it's a webinar, so it's being held remotely. So please do bear with us if we run into any technical difficulties, and we'll try to resolve those as soon as we're able to. As attendees, you're all on mute, but hopefully you can hear us and see the slides on your screen. The webinar is listed to last for an hour, so we'll be done by 11. If you've got any questions as we're going through, then please do put them in the chat box, and we'll endeavour to get to those at the end of the webinar. If you do leave a question and we're not able to respond to it on the webinar, then we'll come back to you later on. There will be a few interactive polls during the webinar, so please do get involved with those. And if you do get interrupted, or you have to leave early, or you just want to rewatch the whole thing again another time, then there'll be a recording which will be sent out later today, I believe. A copy of the slides is available for you to download in the handouts section on the platform. So just make sure you do that while the seminar is still running. Okay, I think that covers all of my housekeeping points. So let's move on to the first slide on the contents of today's talk. So in a moment, I'll just do a little introductory spiel about the tribunals and sort of how things are looking at the moment. And then essentially after that, we'll be going through each of the different stages in the tribunal process. So starting off even before a claim is issued, including the ACAS Early Conciliation process, then moving on to reviewing and responding to a claim once it's been received. So that will cover both what you can do as a business, steps you can take when you've got a claim in, and also what your lawyer would be doing, what we would be doing to assist you at that stage. I'll talk as well about preliminary hearings, case management orders and applications, what's meant by all of that. And then at that stage, I'll hand over to Emma, who will run through disclosure of documents, witnesses and witness statements, settlement and settlement negotiations, and finish off with a bit on remedies. Now, one area we're not going to really spend any time on today is the final hearing itself. And there's good reason for that, because we've got a mock employment tribunal that we're in the process of organising for the first half of next year. We're going to be running that in conjunction with Devereux Chambers. So hopefully these are all this talk and the mock tribunal will collectively give you a really good insight into the tribunal process and what to expect. Okay, so on the next slide, just a little intro for you. So why do the seminar on preparing for tribunal, aside from the fact it fits in very nicely with our mock employment tribunal plans for next year? I think there's a few things here. So as a team, we're definitely seeing an increase in the amount of employment tribunal litigation that's coming into us. And in conjunction with that, we're also seeing a decrease in the number of claims that are being settled, particularly claims being settled at an early stage. Now, I guess you could speculate as to why that is. You know, potentially cost of living concerns. People are less inclined to walk away from a claim at an early stage with a relatively low value deal, and they're holding out for a bigger reward. But regardless, we're definitely finding that it's a bit more tricky to settle tribunal claims early on in the process. In addition to that, it's taking, I think, longer and longer for the tribunal process to actually run its course. So some figures I was looking at the other day, for most of the last decade, so the 2010s, you had about an average wait time of 30 weeks between the date that a claim was presented and the date of a first hearing. Now, that's not necessarily the final hearing, that's just the first hearing, so it could be a preliminary hearing. Figures are a little bit vague, but 30 weeks from issue of claim to first hearing. By 2019, pre-pandemic, that had gone up to 38 weeks. The latest figures we've got now are that it's an average of 49 weeks, so nearly a year from a claim being presented to the first hearing in that claim. And even that's an average figure. So you've got certain parts of the country where the tribunals are under more pressure. Unfortunately, Reading, Watford, London, the Northwest, I think is another area where the figures are probably even worse than that. So, if you sort of look at it all in the round, you've got quite high volumes of litigation, hard to settle them, claims lasting for a long time. I think everybody knows that it can be pretty stressful and disruptive to deal with these claims. So all in all, we felt it was just a good time, a good opportunity to run a webinar on this topic. I think it's helpful for you to know what to expect, both so you can feel familiar with the process, and also so that you can help support your colleagues within your businesses as and when these claims arise. Okay, so that leads us on to our next slide, which I think is our first poll question of the day. So around the number of tribunal claims issued. So hopefully this poll question will appear on your screens now. So during the quarter April to June 2023, how many new employment tribunal claims were issued? And you've got four options there. So 5,000, 51,000, 23,900, or 12,000. And we'll just give everyone a moment to speculate on how many claims were issued in that quarter, and wait for the results to come up. So 61% of you think 23,900, 61% of you are correct. So that's the number of claims that we had in the April to June 23 quarter. Not as many as 51,000, thankfully, but still, very, very substantial number of claims. If you scale that up to a year, that's over 95,000 claims to the tribunal each year, or it's over 1,800 claims every week. So if you do get a claim, you're certainly not alone in that respect. Okay, let's move on to the next slide then. So before a claim is issued. Now, while some claims do come a little bit out of the blue, generally claims are not, or perhaps shouldn't be coming as too much of a shock. It's if you've got somebody who's submitted a formal grievance, they've written a very terse, angry resignation letter, being critical of steps companies taken. Obviously, if you dismiss somebody for conduct or performance reasons, then these are obviously the cases where there's clearly going to be a high risk that will turn into tribunal litigation. Clearly, it's key that your main policies, your disciplinary, your grievance, your performance improvement processes are all kept up to date, that managers are aware of those, and that those processes are being consistently and reasonably implemented as and when issues arise. Obviously, it's important while running these processes to be mindful of potential litigation and to keep HR personnel in the loop. If there are any appeals at the end of these processes, then that can be quite a good opportunity to review and address any failings, whether they're more procedural in nature or whether there's a substantive issue that's been missed. Now, of course, you could do all of this wonderfully and correctly and still end up with a claim, but there's one step that employees have to go through in the vast majority of cases. They need to contact ACAS, which is the Advisory Conciliation and Arbitration Service, to begin early conciliation. So they must do that before they can submit the claim. Now, early conciliation is an opportunity to settle a claim at an early stage. The employee doesn't have to do a great deal, just provide limited details such as their own name, the name of the prospective respondent employer. It lasts for up to 6 weeks. It used to be a month, so a month, and you could extend it for up to 14 days, but it's now just a flat period of up to 6 weeks. But the parties don't have to take part, so there's no obligation to take part on either the claimant or the respondent in the early conciliation process. If you do take part and it is successful, then typically what will happen is you'll draw up a settlement agreement or a COT3 agreement via an ACAS conciliator, which is great. Case has then been settled, don't need to worry about the rest of the process. But on the other hand, if it's not successful, then the early conciliation process will be brought to an end. The prospective claimant employee will get an early conciliation certificate with a number that they have to include on their claim form, and they can then proceed to bringing a claim. Now, one additional point I just wanted to flag is around contact details. So ACAS do maintain a database of contact details for early conciliation. It was principally set up for large employers, very large employers with over 1,000 employees perhaps. But we were just checking the point yesterday, and actually there's nothing to stop any employer from writing to ACAS at this email address here on the slides and designating a point of contact for early conciliation. And it may be something to think about if you just want to make sure that if an employee does bring a claim, that ACAS are then getting in touch with the person you want them to speak to about the early conciliation process. Okay, next slide, receipt of a claim form. So what an exciting set of slides. We've got a few here. I think this is probably the highlight on this screenshot of an ET1 form. This isn't the whole form, it's just the top of the first page. The whole form is about 12 to 15 pages long, unfortunately. But you can see there on that screenshot, the claimant's got to provide details about themselves. They've also got to provide information about the respondent. There are a whole series of sections for them to fill in. So have they got another job? What were their dates of employment with you? What were their earnings? What are the legal claims they're pursuing? What are their grounds of complaint? So what are the facts that they're relying on to pursue these legal claims? What's the remedy that they're seeking? Do they have a solicitor representing them? This is all the information that goes into the ET1 form. So if we move on to the next slide, once you've got one of these ET1 forms in, it will be enclosed with a notice of claim letter that will identify the claimant employee, and it will identify the respondent employer. And I think obviously the first thing you're going to want to do is take a look at those documents, so review that notice of claim letter and the ET1 form to understand what the claim is about. Obviously important to diarise the response deadlines. So the notice of claim will set out a deadline for you to submit your response by, and any other dates that are included in that notice of claim letter or any accompanying documents. Number 3, underlined, very important. Please, if you do want to be legally represented when defending a tribunal claim, send on that notice of claim letter and the ET1 form to your solicitor as soon as you're able to. The earlier we are involved, the easier it is, the less rushing about there is trying to get a response pulled together before the deadline. And then fourthly, if you are able to prepare as soon as you can a summary of the key facts, start to collate key documents, then again, that just helps your lawyer to get up to speed with the background to the claim more quickly. Okay, so next slide. What will your lawyer do? think we just skipped on one slide there. So if we just go back to the previous slide, number 1 of 3, there we go. So obviously you need to understand the facts and the claims. So that's going to involve some initial calls and meetings with you to discuss the background and explain how the tribunal process works. Of course, we'll need to review all of the key documents. So in addition to the notice of claim letter and the ET1 form, grounds of complaint, we'll want to take a look at any relevant contracts of employment, any letters that have been exchanged between the parties, emails, key policies in your staff handbook as well. For large employers who are part of a big corporate group, we want to check that the correct respondent has been named. So the correct entity is responding to the claim. And we'll also want to check whether there's been any claims brought against individual employees. Typically, you might see that in a discrimination claim. So somebody brings a claim of discrimination both against the company and against an individual person within the company who they feel has been responsible for that. Sometimes it can be a little bit tricky for a solicitor to act for both the company and the individual in that circumstance. There could be a potential conflict of interest further down the line. So in those scenarios, it may be that the individual needs to seek their own representation. Assessing whether claims are in time, that's another job we will do. So for the majority of claims, the relevant deadline you're looking at is 3 months less 1 day from the act complained of. So in your classic unfair dismissal scenario, if somebody's been dismissed on the 8th of August, you count forward your 3 months, September, October, November, then back a day, they've got a deadline of the 7th of November. Now it's not quite that cut and dry because of the impact of the ACAS Early Conciliation rules. So essentially you've got a bit of a stop the clock rule on ACAS Early Conciliation. So essentially what will happen is that the deadline for presenting the claim will be extended by the duration of the ACAS Early Conciliation process. So if it lasts for the full 6 weeks, that will push the deadline back 6 weeks. If it only lasts for a shorter period of time, say a couple of weeks, then the deadline will be extended by a couple of weeks. Now, in addition to that, the deadline will then be extended again if the deadline, as extended by the stop the clock rules, is less than a month after the date on which early conciliation concluded, so the date of that early conciliation certificate. So in that case, the deadline will instead be 1 month after the end of ACAS early conciliation. So the claimant's employee is always going to have a month from the date of early conciliation in which to actually present their claim. Okay, moving on to what will your lawyer do, slide 2 of 3. Some eligibility criteria to consider. So employment status is obviously key in terms of the types of claims that an individual is allowed to pursue. So certain claims such as unfair dismissal or claim for a statutory redundancy payment rely on that individual having employee status. Other claims, you don't have to be an employee, but you've got to be a worker. So claims for national minimum wage, for example, for holiday pay require worker status. If you're contracted, there's much more limited set of claims you can bring. Jurisdiction issues, so the tribunal can hear breach of contract claims, but only up to £25,000. There could also be jurisdiction issues if the individual is working abroad. We may need to review clauses in their contracts around jurisdiction to see whether claims are actually not governed by laws of England and Wales, but by some other jurisdiction. Some claims could be excluded, so you've got this res judicata principle. So if they've already brought a claim on the same facts, they won't be able to pursue the same claim again. Likewise, if they've entered into a settlement agreement previously that's a valid agreement and that's waived claims, then those claims should be excluded and won't be able to be pursued any further. And length of service. Length of service is a key one for certain statutory claims, and that brings us on to our next poll question. So we'll get that one up. What length of continuous service does an employee require in order to bring an ordinary unfair dismissal claim. So you've got 4 options here. It's either 6 months, a year, 2 years, or 4 years. So just give you a couple of moments to input your answer there. Wait for the results to come up. Here we go. So yes, very good. 96%, spot on. It's a 2-year period to bring an ordinary unfair dismissal claim. It used to be less. Used to be a year. It'll be interesting to see whether this is something that changes in due course. If there's an election next year, I think polls indicating Labour government's perhaps more likely. This might be something that they look at reducing. I think when we had the Corbyn administration in charge, they were talking about day 1 unfair dismissal claims. Don't think we'll get that from Keir Starmer, but it could change. But at the moment, no news about that, and it's a 2-year period. So let's move on to the next slide. 3 of 3 on what will your lawyer do at this stage. So having reviewed the papers, having considered these eligibility, jurisdiction issues, lawyers should be in a position to give you an initial view on costs, prospects, and quantum. So costs being the costs, your legal costs to run the defence of the claim all the way through to a final hearing, prospects of success, and quantum as in the value of the claims if in the event that the claimant were to be successful with all of the claims that they're pursuing. And the initial view that we give on that may help inform your approach to settlement, which Emma will talk about a little bit later. Probably the key thing really that all of this leads up to is drafting and submitting the response form. So that's done on the ET3 form. You've got 28 days from receipt of notice of claim, unless you get an extension of time, to submit that response form. The response will want to address the legal issues, of course, but also the factual issues, and identify flaws and weaknesses in the claim. So typically what you would do is you would go through the grounds of complaint and either admit or deny or put the claimant to proof in respect of the statements and allegations that they're making. The approach does need to be tailored a little bit depending on the style and quality of the ET1. Perhaps unsurprisingly, if you get something from a litigant in person, it can tend to be a little bit all over the place. So we just have to tailor our approach depending on how the claim has been set out. Obviously, in order to do that, it does rely on the timely provision of information that we request from you. So we're up to speed and we've got all the information we need to respond, particularly to the factual part of the claim. And when the ET3 is all finalised and ready to submit, well, what we've typically done to date is you just file off an email to the tribunal and you get an automatic email back acknowledging receipt. There is, however, now a bit of a move to this new HMCTS portal. At the moment, the functionality is a little bit limited, and it's mainly just for submitting a claim if you're the claimant, or responding to the claim if you're the respondent. But there is some additional functionality that's going to be rolled out, and they're currently trialing it in a few places around the country, so that people can use this portal to put applications in as well. And I'll come on to applications in a moment. And finally, just one other point on considering a counterclaim. So obviously the tribunal process is mainly to deal with claims that an employee is bringing against an employer. And there's no freestanding right for an employer to do the opposite and bring a claim against the employee in the tribunals. But if the employee does bring a claim for breach of contract, then there is the opportunity for you to run a counterclaim for breach of contract in the tribunal. So that's something that we just apply our mind to if it's relevant on the facts. Okay, next slide. So once the response has gone in, there'll be an initial assessment by a judge. A judge will consider, are there any reasonable prospects of success for these claims? are these claims in the tribunal's jurisdiction? If the judge does feel there's no reasonable prospect of success, or that certain claims are outside the tribunal's jurisdiction, then those claims may be struck out, subject to representations from the parties. However, more commonly, what you'll get, particularly if there's a discrimination claim, is that there'll be a preliminary hearing for case management that's listed. You do sometimes get case management directions issued at this stage with the notice of claim, after the submission of the response, on more straightforward cases, but quite typical to get preliminary hearings listed now for these case management issues. So what happens at a preliminary hearing? So on the next slide, often by phone, although they can be by video or in person. I was just reading an update last night saying that from the 20th of November, tribunal hearings, including preliminary hearings, are going to be recorded. So it'll be an audio recording of those hearings, but that's only where the equipment is available, and I'm not sure that the equipment is actually available in that many hearing centres at the moment. It's also going to be, there's going to be quite limited purposes for which that can be used, principally by the tribunal to sort of go over what was said when preparing judgments, etc. But anyway, often by phone, these preliminary hearings. Beforehand, parties are typically asked to complete an agenda. There can be quite a lot to fill in there, setting out the list of all the legal and factual issues, identifying witnesses that you want to call, and both parties are asked to complete that agenda. At the hearing itself, often they're used to clarify the claims being pursued, particularly if you've got a litigant in person. Judge may work through the claim form with the claimant to actually establish what the legal claims are and what the factual basis is for those claims. Case management orders which will be issued, which I'll come on to in a moment. Sometimes you can have a preliminary hearing to determine a preliminary issue, such as whether the claimant's got the required employment status to pursue the claim that they're bringing, determine whether they're disabled, whether any time limit issues apply. It's not always the best move to push for a preliminary hearing to determine these sorts of issues. Needs to be assessed on a case-by-case basis. A lot of the time it can require quite a lot of time and preparation to attend all these preliminary hearings to determine a preliminary issue. And the tribunal can often need to sort of assess quite a lot of the factual background in order to give a judgment on preliminary issues. So it's not always the most efficient approach, but we'd assess that on a case-by-case basis. And you may at this stage also get confirmation of the final hearing date. Now, preliminary hearings will be held in private unless certain applications like strikeout or a deposit order is applied for. And again, I'll come on to that in a moment. So next slide on case management orders. This is essentially an instruction from the tribunal for the parties to do something by a set deadline. They can be issued at any time, but it's typically during or shortly after a preliminary hearing. Can include directions around schedule of loss, so claimant has to prepare a schedule of loss, directions around disclosure of documents and witness statements. But essentially, it's all about preparing the case for a final hearing. And of course, important to diarise these dates. Sometimes there's a bit of a lag between a preliminary hearing and actually getting written confirmation from the tribunal of the dates of these various orders. And if you are going to have any difficulties in complying with the orders, it's important you let your representative know as soon as you can. Final slide for me is just briefly to run through some of the types of applications you can make. So sometimes you might want to apply for an extension of time. You need good grounds to do that, but if you needed more time to file a response, you can apply for further and better particulars of claim if the claimant's claim form isn't clear as to the legal claims being pursued or the basis for those claims. You may want medical evidence if you're disputing disability. Strikeout if you feel that the claimant's claims are weak and you want to apply for strikeout of all or part of their claim. Often the only alternative, you might seek a deposit order, so the claimant has to pay a certain sum of money, up to £1,000, as a condition of being able to continue to pursue certain claims. And you can also have unless orders, so that's an order which, unless complied with, would automatically result in the strikeout of all or part of the claimant's claim. So that is the end of my section, and I will hand over to Emma to talk about disclosure.
Thank you, David. So just referring back to some previous slides of David's in relation to the case management orders that the tribunal may make, either of their own volition or at a preliminary hearing. The first one of the case management orders that, as parties to the litigation, you'll be asked to comply with is that of disclosure. And that is a duty on each party to disclose to the other all documents that they hold, which are relevant to the litigation, and that's whether or not they are helpful to your position in the case or not, unfortunately. So if there is some unfortunate email where a comment is made that is relevant to the litigation, it will still need to be disclosed, even if that may hinder your defence to a case. So the duty is to disclose all relevant documents, as I've said, and that includes all hard and soft copies. And as you know, technology is progressing, we're seeing more and more things like Teams or other chat functions that companies are using internally. So it's applying your mind to what else may we have, rather than just contractual documents, hard copy documents and emails. Are there messages on our internal chat function, our Teams, that also need to be disclosed in this litigation, and thinking about that more. The duty upon both parties is to undertake a reasonable search of the documents that they hold. So that may require, you know, word searches of individuals' names and things within the internal storage systems that you may have. And evidence must be preserved. So, as David mentioned earlier, you may have an employee who had previously raised a grievance or been through a disciplinary. In those circumstances, you probably should be applying your mind to the fact that this may not be the end of that scenario, and something may arise in relation to that later on, and ensuring that you're preserving any evidence relating to that situation. Because of course there could be documentary evidence that you have which is very helpful to your position, so making sure that you're preserving all that you need to. Now, there will be some confidential information contained in some of those documents. It may include names and details about others that the claimant in the litigation doesn't have the right to see, so ensuring that a full review of those documents takes place before they are disclosed, so that anything can be redacted. Of course, you know, we will do that as part of our review process, disclosing them to the other side. Moving on to our next slide on disclosure, a little bit more about some other obligations in relation to this, as well as not disclosing confidential information about parties that aren't involved in the litigation themselves. We also have a requirement not to disclose privileged documents. So if you've sought legal advice from us or another law firm, or you've engaged in some form of without prejudice discussion with an employee before their exit, privilege can attach themselves to those documents as well. Again, if those documents are provided to us as part of that process and is looking at what needs to be disclosed and what doesn't, we will assess if there's any privileged documents that shouldn't be disclosed. What the claimant will do is the same as that. Again, that will depend somewhat on whether or not they are represented or not, as to how useful and easy that disclosure process is. But as part of the claimant's disclosure, they will also be providing what we call mitigation documents. So that should show the steps they've taken to try and secure new work, what jobs have they applied for, if they have found a new job, the contract and some pay slips for that new job, so that we can make an assessment on, well, how long were you out of work, and what are your losses if you found a new job very quickly and you're on a higher salary in that role. What can be useful for employers to do alongside that is also keep an eye on the job market at that time, look at the jobs that are available that the claimant could do, and then if the mitigation documents that come through from the claimant are not sufficient, then we always have those to rely upon. If it got to that stage at the tribunal and we were discussing remedy, we would have some arguments that the claimant hadn't sufficiently mitigated his or her losses. So once we have all the disclosure, once our client has provided all of that to us, we will create a list normally a chronological list, but split into different sections, tribunal documents, correspondence, however we wish to do it. And we will exchange those lists with the other side, and that will be on a date that has been ordered by the tribunal. It should be on the same date. It's not as crucial as happening at the same time as witness statements, which we'll get to later. And then on the receipt of those documents, we will have a look at, well, is there anything on the other side's list that we don't have? What would we like to see from their list? And request copies of those as required. Now, on receipt of that list, if there are glaring holes in the disclosure, we know that they, I don't know, have been engaging in email correspondence with a colleague and then deleted it all from the server before they left. And we know that they retained copies of those emails and they are provided as part of the claimant's disclosure. We would perhaps be asking them for specific disclosure of those documents. They're documents we believe exist but haven't been provided as part of the disclosure process. And they may equally ask the same of us. Sometimes that can be a little bit seen as a little bit of a fishing expedition by either party to try and get their hands on other documents that perhaps aren't relevant. If the parties can't agree between themselves on what should be disclosed, whether something needs to be disclosed specifically after such a request, then an application may be made to the tribunal, and the tribunal may make a finding in respect of that if necessary. But if the parties can obviously agree disclosure between themselves, that makes the process much easier, smoother, and having to involve the tribunal at the disclosure stage is going to delay the litigation overall. The duty to disclose is ongoing throughout the matter. So if you suddenly find an email on your system or server that is relevant, but that is after the date of disclosure, or even after the date that a hearing bundle has been prepared, then that does need to be disclosed. And we do find in litigation that the parties may be disclosing documents to each other actually right up until the hearing. Sometimes after the exchange of witness statements, people suddenly remember there was a document that supports or can help deny what someone is saying in a witness statement, and documents will tend to be disclosed at that time as well. The earlier though, the better. And then what will happen once we've agreed the contents of the disclosure between the parties is produce a hearing bundle, and that will be the bundle of documents to be used at the hearing. References will be made in witness evidence to the documents in that bundle and draw the tribunal's attention to a particular letter or email that we need to. Now, due to COVID, the tribunal system went quite heavily online, or almost all online, certainly during COVID, and that's continued since that time, and that has resulted in, rather than cumbersome hard copy lever arch files or bundles being produced, that electronic bundles are now being used, which make them much easier to search on screen, to find keywords, to find key documents. I find a much more usable way to do it, and obviously if the hearing is going to be held via video, then the electronic bundle will be used in that scenario. Moving on now to the next part of the process, which is witnesses. So once you've agreed all the documents, and hopefully there's some documents in your bundle that assist you or are going to assist you in being able to defend the claim that's been issued against you, you also want to think about the witnesses that you want to call, because there will be some facts or points that cannot be determined by documents and will only be able to be determined by witness evidence, particularly conversations, witnesses to altercations that may have happened or something like that as part of a process that led to a disciplinary and ultimately a dismissal. Looking first at an unfair dismissal claim, most commonly you would want there the person that made the decision to dismiss, so those that were involved in the process, the investigation, the disciplinary, and that the person that made the decision to dismiss, and the person that ultimately heard any appeal. There will be three different people in that respect, or should be three different people in that respect, dealing with those different elements. Of course, if we've got a claim where there are discriminatory elements as well, there may be other key witnesses that can give evidence on whether or not something was said or not, if they heard it, and give evidence in respect of that. But for an unfair dismissal claim, you're at least going to have those 3 individuals. And I suppose thinking of that, you know, if you've got 3 individuals that have to provide evidence in the employment tribunal, thinking about the time and cost involved in preparing that witness evidence, having those witnesses available to speak to us, to give us their version of events, to engage with us in the preparation of their witness statements and its approval, and then ultimately happen to attend the hearing. So all factors that we have to consider in respect of the commerciality of proceeding all the way to a final hearing, and whether or not settlement might be a better option on that basis, and we'll come to that later on. So one of the key points is, are the witnesses available on the date that the hearing has been set? And that would have been set at either a preliminary hearing, as David said earlier, or the tribunal may have just issued a date to the parties. If they are not ready or willing to attend, then, well, firstly, if they're not able to attend perhaps for things like a pre-booked holiday or a medical appointment, then the tribunal will, if you have supporting evidence, allow the hearing to be postponed if you have a valid reason. They won't continue to allow that to be postponed time and time again. When we're seeking a postponement of the hearing from the tribunal, we should make sure we're providing them with any other key dates that witnesses may be unavailable. Alongside this, we need to think about whether individuals may be willing to attend a hearing. And then there may be circumstances where individuals don't feel comfortable in attending a tribunal. They're nervous about the process. They're worried about repercussions, perhaps from the claimant. They had a bad experience before, perhaps if they're an individual that works in HR and they've had to attend a tribunal before and they found that particularly difficult. So what we can try and do for you here is speak to the witnesses on your behalf, explain to them as best as we can what the process will entail, try and make them feel comfortable in giving that evidence, and letting them know as best as we can what that tribunal process will be. And thinking about as well the characters of the witnesses that you may have. Are they going to come across as a credible witness? Are they going to be able to withstand the pressure in the witness box when they are cross-examined by the other side, if they appoint a barrister, questions by the judge? How is that individual going to hold up? Because yes, you want your employee to give witness evidence on the company's behalf to help defend their position, but ultimately they are still your employee, and you don't want to put them in a position that makes them feel incredibly uncomfortable and could be, you know, cause them undue stress. So it's about managing that process as best as we can. Up next, a little bit more about witnesses. Other issues that you may come across when selecting your witnesses, as I've already dealt with being unavailable, that may be due to a pre-booked holiday or medical appointment, and as I said, in those circumstances we should be able to get a postponement if we have evidence to show that that was in place before the tribunal set the date. Other things may be someone being unwell at the time of the hearing. We could seek a last-minute postponement, again, if someone is unwell and unable to attend the hearing, if we have medical evidence. The thing to factor in there is, of course, if everyone's ready and willing to go to the hearing, if you've instructed your barrister and you've incurred your counsel's fees and then one of your witnesses is unwell, well, you will have to pay your barrister again for any rescheduled hearing. So thinking about the commercial implications of that at that time and the running costs, and the fact that relisting a hearing at tribunal could take, you know, another 6 to 8 months, by which time has people's and your witnesses' memories faded in respect of the witness evidence that they can give. As I said, there may be some individuals that are unwilling to give evidence. We can help try and manage that process as best as we can, but as I say, it's a balancing act between not wanting to force a current employee of yours to give witness evidence on your behalf if that would place them in a difficult or uncomfortable situation, or a situation that may be detrimental to their health. But again, balancing that on putting you in the best position possible to be able to defend the case that's been issued against you. When an individual has left the company, of course, there is again no obligation on them to provide witness evidence on behalf of a company that they used to work for. It will somewhat depend, I think, on how that individual left. If it was under a settlement agreement, there may be a clause in there that says they will give reasonable assistance. But of course, you can't entirely control what someone might say in the witness box when cross-examined. And if you're asking a former employee to attend on your behalf to give witness evidence and they left on not the best terms, that may be something you'll want to avoid if there was a breakdown in the relationship before they left, because ultimately you can't control what they may say in that witness stand. And one other thing which is reasonably new to sort of the witness statement arena is when an individual is proposing to give evidence from abroad. Before, as I understand it, you would either have to get them to attend or they could give evidence via video link. That can still happen, but now you need to seek the approval of the tribunal to be able to have a witness give evidence from abroad. And again, that can just cause some extra administrative burden, costs, and delay to the process. Moving on to the witness statements themselves. So once you have decided who are going to be your key witnesses, we need to produce witness statements. The way that we would usually do this is to speak to each witnesses, take their first-hand knowledge, where at all possible, about the scenario, asking them questions about what was said at this meeting, what did you hear during this conversation, and referring to the bundle of documents, which we discussed earlier, that has already been produced. Because ultimately what we want to be doing through the witness statement is telling the story in the witness's own words, making sure that we are setting the narrative in the way that we would like it to be set in order to put the respondent's case in the best position possible, or defence to the case in the best position possible, and referring the tribunal to the key documents that support the points that we're trying to make as we go through that witness statement. What is key, and as David said, is because it takes such a long time from perhaps issuing of the claim to getting your case all the way to a final hearing, is thinking about who those witnesses are going to be early on and having an initial conversation with them to try and note down key points while things are still fresh in their minds, because as you all appreciate, as time goes on, memory fades. Yes, you can show them documentation and that may jog their memory, but the sooner we can get those key issues down, the better. Now, statements are evidence in chief at the tribunal, so they are, as I said, exchanged with the other side in advance of the hearing, simultaneously, so neither party will see the other statement in advance, and then they are provided to the tribunal, and the tribunal will take them as read. So you won't be asked as a witness to stand up in the tribunal and read out your statement. You'll be asked to swear on oath or affirm that the contents of your statement is true and accurate, and you produced it and you've signed it. But otherwise, the judge and the panel members, if there are, will read the statement in advance or at the beginning of the hearing, and then you will be, as a witness, cross-examined on the contents of that. Moving on to the next slide, some further points, I think, on the claimant statement. Oh no, sorry. Witness statements continued, apologies for that. So, as I said, you're asked to, or the witnesses will be asked to affirm or swear on oath that what they say in their statement is 100% true. So that's why it's very key that the production of the witness statement is a collaboration between your lawyers and the witnesses themselves, so that the witnesses are entirely happy with what they are saying in the statement. Of course, as lawyers, we want to provide input so that what is said in the statement puts your case forward in the best way possible, but it has to be in line with what the witness is happy to say and what their recollection of events are. And in open hearings, witness statements will usually be available for inspection, unless there are some orders attached to it, which may be that a privacy or restricted reporting order are in place, and that is in very limited circumstances if there's particular cases which are have issues in there which shouldn't be publicly reported, or national security proceedings, then those witness statements won't be available publicly to read. But again, if they are, that's why it's imperative that they, firstly, are 100% true, but secondly, they put forward the employer's position in the best way possible, because they are going to be available in open hearing and other people could read them, who are not party to the litigation. Now, once the witness statement exchange has taken place, we will be in receipt of the claimant statement, and we deal with that on the next slide. So on receipt of the claimant statement, what we would usually do is ask all the other witnesses or our employer client to have a look at what the claimant says in the statement, and of course we will review that and see if there are any disputed facts in there, if there are any new issues that we've not covered off before in our statements, if there are additional points that we may want to think about covering off in cross-examination, are there additional documents that we need to disclose, and thinking about those things on receipt of the claimant's statement. It's very useful to get the other witnesses' input on anything that the claimant says, because either our barrister or us, if we're doing the advocacy, those are the points that we want to pick up with the claimant in our cross-examination. So moving on, once the statements have been exchanged, this may then be a time to reconsider our position on settlement discussions. Now, you may have considered that right at the outset on receipt of the claim form, and at other times, well, firstly during the conciliation process, and then again maybe on receipt of the claim form when you've spoken to your instructing solicitors about that, and they have advised you on what the likely costs are going to be to defend the case all the way to a final hearing. But you can engage in settlement discussions at any stage in the litigation. Sometimes that may take place before witness statements have been prepared, because witness statements are probably one of the most costly parts of the litigation. So you may think that before engaging in that process, settlement discussions could take place. Otherwise, on receipt of the witness statements, there may be something in the claimant statement which concerns you and us about your prospects of being able to defend the claim in the way that we had originally thought, and we may want to engage in settlement discussions again, and that would be through things like the ACAS process, or having without prejudice discussions with the other side, judicial mediation, which is a mediation at which the judge plays sort of an independent mediator role, or judicial assessment, again, which is something where a judge will have some input on an assessment of the claims and basically trying to engage the party and trying to settle them before going to a final hearing. And then moving on to my first poll. So thinking about settlement, the number of Employment Tribunal, so during April to June 2023, how many claims were reported by the Ministry of Justice as being disposed of before a final hearing? So we've got 13,800, 20,200, 2,700 and 17,100. Just give you a few minutes to vote. So I can't actually see the percentages on my screen, apologies for that, but from looking at it, I think most of you have said 13,800, which is actually the correct answer. So I think if we think back to the first slide, the first poll, it was around 23,000, I think, claims that have been issued, and of those, we've got 13,800 that have been disposed of. So still, more than half. Lots of cases do resolve before the final hearing, but you can find that it's literally at the doors of the tribunal after all the work has been done. And then I think just moving on to one of my final slides, the final hearing itself. As David said, we're covering this off in quite a lot of detail at the upcoming mock tribunal event, but this is just some headlines about the hearing, more about the preparation for the hearing. So preparing your witnesses, reminding them of the hearing date, where the tribunal is and what will be expected of them. and we can have conversations with the witnesses to provide all that information to them. Familiarise the witnesses with the witness statements and documents. It's very key. You're going to be taken, or witnesses will be taken to parts of their statement and parts of the bundle by the other side in cross-examination and by the judge. So as familiar you can be with those documents as possible will make the witnesses much more comfortable. And then the next slide, we cover off a little more about once you've had the hearing and the judge makes his or her judgment and gives a remedy. These are some of the possible outcomes. Again, this will be covered in more detail in our mock tribunal because we will, I'm assuming, reach a judgment and perhaps issue a remedy at that. But just thinking about the judgment can be given at the end of the hearing, or it may follow in writing if there isn't sufficient time for the tribunal to deal with it. And some of the remedies that a tribunal can make are compensation, and that is for loss of employment, loss of salary and benefits, and that would attach normally to a claim for unfair dismissal. If it's a discrimination claim, you've got injury to feelings awards. They may have contractual claims or statutory payments. They may ask to be reinstated or re-engaged into a job. They may ask the tribunal for a recommendation. And lastly, costs. The tribunal is generally a cost-neutral venue. Each party bears their own costs, but if there is conduct by either party which is unreasonable, a claim has been pursued vexatiously, there are grounds to seek costs from either party, and application can be made in that respect. I think the final poll is in relation to cost awards. So in the period 2022 to 2023, of the 195 cost awards made, how many were made in favour of respondents? That is employers, so they would have made those applications because of unreasonable conduct by a claimant. Just give you a few moments. So I think the most there is 30. It was actually 150. So quite a large proportion. Lots of unreasonable claimants it must have been in that period of time. The tribunal were quite keen to award cost awards for respondents in that period. I think moving on, we now invite questions from everybody, I think, please.
Yeah, so I think we're a little short on time for questions, but I'll just pick up one that's come in on the ACAS Early Conciliation, and somebody's saying we don't always hear about early conciliation, don't get any contact from the ACAS conciliators. Why is that? And the answer is that, well, as I was saying before, early conciliation is not compulsory for both parties. So if the claimant has already told the conciliator that actually they're not interested in taking part in early conciliation, then in that case the conciliator wouldn't necessarily contact the respondent, and then the first thing that you would actually hear about a claim is when that claim form lands. So that's why sometimes you don't hear about the early conciliation process. I think we've got a few more questions, but we're a bit short on time to answer those now. So we will come back to you on email later on for those questions we haven't been able to get to. Thank you very much for attending today. When the webinar platform closes, please do complete our short survey and you'll be entered into a draw for a John Lewis voucher. And finally, just a little bit about our next events. So next week, next Thursday, I think we've got the immigration update webinar from 10 till 11:15 a.m. Do sign up for that one. In January, we've got probably our biggest event of the year, the annual employment law breakfast briefing. My colleague Ian McRae will be running that at Green Park in Reading. And then, as we said earlier, we've got the mock employment tribunal with Devereux Chambers in the first half of next year. So I hope you've enjoyed watching today and have picked up a few pointers. Thank you very much and have a great rest of your day.
Thank you.